and then when the person becomes an adult and it continues, somehow changing the age at 18 makes a difference regarding the initial molestation that continued and maybe, let's say, culminated in a rape.
Well, those adult acts, Your Honor, would be different torts or different crimes, but they would not fall under the definition of childhood sexual abuse under subsection 5. And that interpretation.
So we're not dealing with a cause of action under this statute. It's about statute of limitations, tolling. So what I'd like you to help me understand is, how does grooming play into this? Or as far as you're concerned, and it appears the Court of Appeals agreed with you that grooming had no play in, or has no play in, a sexual abuse scenario. Would that be accurate?
Well, Your Honor, grooming whatever the Grooming Act was would have to satisfy the definition of subsection 5. And there are many acts of grooming that are deplorable, but they would not fall under that definition.
Right. And that would be something for the jury to decide. So what I'm trying to have you explain is, an individual, let's take the facts in this case, has an act that has to be determined by a trier of fact occur when they're 17 or 16, and that act with the same perpetrator continues on in a different form when they turn 18, and then when they turn 20, and then when they turn whatever other age, until they come to realize what has occurred. Are you saying the language, the injury suffered in subsection 1 as a result of the sexual abuse in that scenario does not tie back to that first instance of molestation, or does it?
The state's argument is that those subsequent acts are themselves independent torts, and they are not an injury of childhood sexual abuse themselves because they occur in a person's adulthood. And
under your interpretation, there can never be continuous abuse.
no, Your Honor, there can be continuous acts, but those acts would be subject to different rules of statute of limitations.